as I stand to support the bill. Since I came to Parliament in 2017, I have always felt very uncomfortable that any form of dispute between the two houses would actually escalate beyond Parliament Square and beyond the confines of the offices of the two speakers. I just hope and pray that the spirit and the words of this bill will cure this discomforting situation that we normally find ourselves in to wrangle between the two houses. Honorable Speaker, the Senate was established with a very clear mandate under the law, under the Constitution. The National Assembly was likewise established with very clear mandate under the Constitution. There ought never should have been sibling rivalry. Never, never, never. Sibling rivalry is actually, Honorable Speaker, an indication of why the one house having very little to do, so that when the moment of idleness, you pick anything you want to do. It could also be a symptom that the other house that is charged to doing so much is either too busy, is inadequately resourced to a point that does not have enough time to address all pertinent issues. Consequently, the other house takes advantage of the lacuna and generally takes over the matters that are not theirs. Honorable Speaker, I've had occasion at one time to attend a mediation committee in an area where I'm an expert. Honorable Speaker, I had to tactfully withdraw because it was becoming difficult to discuss with the members of Parliament who do not understand the subject matter and they purport to be experts in the matter. I had to withdraw because I'm somebody who has gone to school and practiced. I wouldn't want to be embarrassed by people who might not understand the area of study where we are dealing with. I just hope, and I have gone through the act, I just hope and pray, essentially the spirit will allow us to cure this matter. It is embarrassing for the two houses to go to court. Article 95, Article 96 is very clear. Honorable Speaker, at one time I had a sitting with a senator, and he said the Senate represents the counties, and counties are populated by people. So the argument is they have the right to originate and conclude lawmaking process in their chamber because they have legislated for the people. I had to politely remind him, and he was my senior, that Senate participates in lawmaking. It does not make law, save for only the county revenue allocation bill, and to the extent that they also have to pass division of revenue bill by virtue of the Constitution. Coming to the act, let me commend, I hardly ever commend this friend of mine, but today I'm obliged to comment because I think they have done a good, Honorable Samuel Chepkonga has done a good job, and there's some thought process in the development of the bill. Honorable Speaker, allow me just to make a few comments. And my comments will start on clause 11. Clause 11 requires that where there is need to, so they are unable to jointly resolve a question arising under Article 110 of the Constitution, the Speaker in B jointly appoint any person or body of person to make such a recommendation within 7 days on the way forward as may be appropriate. At the Committee of the Whole House, and I hope, Sir George, let me admit I've not read the report, we might have to reconsider to restrict or limit to the types of bodies that can be called upon to resolve such a matter. This legislation, and where I stand, I would propose even the Council of Law Reforms, if it's a legal entity, or of the Attorney General, because he has to give a legal opinion to decide which way forward. Because if we leave it open, a body of persons is so ambiguous that the head of the Speaker can choose anybody within their ranks to purportedly to purportedly review the matter. Number two, Honorable Speaker, I also do not see the essence of clause 12.2 because that's already provided for in the Constitution. It is not a good drafting procedure to lift, copy and paste from the Constitution and put it in a bill of parliament. Probably these are some of the areas that we need to provide for. In clause 12.3, Honorable Speaker, I think this is a bit draconian. I said draconian, so as to say, the relevant departmental committee of where the draconian part, where I disagree here, that the bill or motion be not proceeded, the committee of the House, the committee of the National Assembly may recommend that a bill of motion be not proceeded with by the Assembly for want of compliance with the procedure set out at Article 109(5) of the Constitution. I find this too draconian, too limiting, as we have always done. We don't fix a working system. Let the bill come through the normal second reading. Let it meet its fate at the end of the second reading with recommendations from the committee. Honorable Speaker, when we go to clause 14, and this is very critical, and we are facing the same, Honorable Speaker, it has been several days since this House selected its members for this Employment Amendment Act. Up to now, Senate has not recommended their members, so everything is in the limbo. I would actually suggest, where in clause 14.2, the speakers of both houses shall appoint a mediation committee consisting of equal numbers of each house to attempt to develop a version of the bill that both houses will pass. I would suggest, Honorable Speaker, and I want to suggest to Honorable Chepkonga and Honorable Murugara that we put our timelines, be it a number of sitting, and I will propose 4 sitting days, or if either house is in recess, probably have 14 calendar days. Again, on the issue of the chairmanship of the mediation committee, again, this is where the issues has been a problem. Of course, it says equal numbers. Chair, Honorable Speaker, equal members will never elect a chairman. Because if each party, each group, each delegation, let me call it, goes with a fixed mind, none of them will ever elect any chairman. They will always be stalemate because it's equal number, they'll vote for an equal number. To resolve the stalemate, Honorable Chair, Honorable Speaker, I would propose amendments to an extent that the House that rejected the bill should be the one to form the chair, and the House that originated the bill takes up the vice chair position. Again, how do they resolve disputes? By consensus, or each house votes on a separate way. Another recipe for stalemate, we will never move. So, Honorable Speaker, this is a progressive bill, and I would request that we actually have a lot of input before we finalize. Finally, Honorable Speaker, unless I will allow me to continue as I have several minutes to go, I need your guidance, Honorable Speaker. I just wanted to conclude so that I don't encumber the system.
Order, honorable members. Honorable members, order. Members, the time being 7:01 p.m., this House stands adjourned until tomorrow, Wednesday, the 20th day of March 2024 at 9:30 a.m.